Well, the Constitutional Court has found the Public Protector Busisiwe Mkhwebane had no jurisdiction to investigate the affairs of President Cyril Ramaphosa's 2017 ANC presidential campaign, dismissing her appeal of an earlier North Gauteng High Court ruling that set aside her CR17 Bosasa donation report. Delivering the judgment, Justice Chris Jafta, however, said that the High Court had erred in dismissing the Amabhungane Centre for Investigative Journalism's argument for the disclosure of details pertaining to internal political party funding, and that the court should have considered the merits of that case. Sam Saul is a journalist and managing partner of the Amabhungane Centre for Investigative Journalism, and he joins us now for some reaction to this. Sam, great to have you. Thanks very much for being with us this morning.
Pleasure.
All right, give us your immediate reaction to the ruling yesterday.
Look, we're very pleased because the president and his lawyers mounted quite a strong attack on us being there at all, and as you pointed out, the High Court ruled that essentially our arguments were beside the point and it didn't deal with the merits of the matter. And the ConCourt actually dealt with each of those technical objections to our challenge and dismissed them, and has then now referred the matter back to the High Court for a first judgment rather than dealing with the matter themselves. So at least we get to deal with this principal issue, because we weren't taking sides on the facts of the case. We were saying that if the executive member's ethics code does not provide for the disclosure of this kind of information, of these huge sums spent on internal party battles on the path to power, then it's unconstitutional to that extent. It should make provision for the disclosure of those things. And so we're pleased there's another opportunity to argue that case.
Yeah. So the door is still open, and that's an important aspect of the fight. So you, in a way, I mean, you basically are still in the game. I mean, because that's kind of where we're at right now. I mean, the one side is closed, but this door may still very well be open. What is your next move in this?
Well, the matter will be referred back to the North Gauteng High Court. We obviously have to look quite carefully at the Constitutional Court judgment, because although they did not decide that issue, the constitutionality of the ethics disclosure provisions, they did make some findings around the code that I think perhaps narrow the space for us, but we will look at the judgment very carefully. And obviously, it's a whole new ball game at the High Court, when in a sense the core issues are not clouded by the rather bad case that the Public Protector brought, which I think clouded some of the views taken by the ConCourt in this in this case.
Yeah, which matters, for instance? I mean, give us the understanding there.
Well, look, you know, the issue around whether the code does, as it stands, provide for disclosure of internal party funding. The Constitutional Court appeared to take the position that you know, the enormous sums that went to the election campaign for Cyril Ramaphosa was not a personal benefit for him. I wasn't clear on the logic that they used for that, and they mainly relied on the deficiencies of the actual facts of the case that the Public Protector put forward. So I think those deficient facts and technical legal arguments that she had and made badly perhaps clouded that issue somewhat. We're going to have to think about how we reapproach that. I think there's also a distinction to be made between, well, what do we understand the code to say and to mean and to imply now, from the question the ConCourt did not consider in terms of, well, what should it include? What in terms of the constitutional imperative to make these things transparent, to make the exercise of power transparent in terms of, who are the backers of people who are at the top of our political system. That hopefully will be reconsidered.
Yeah, I want to go back just a little bit to that ruling and get a better understanding of it. Where, as you very rightly said, the court saying that President Ramaphosa did not personally benefit from these funds. But I mean, Sakine and I were having a conversation off air and basically saying, personally benefit. From our understanding, and perhaps we're not reading the ethics right, but when you look at how he did benefit, I mean, he got the highest office in the land. Is that not seen as a personal benefit? He personally is the president of South Africa and the ANC, and those funds did help him elevate to that position. I suppose maybe there's that kind of blurred line there.
Absolutely. I mean, that's the case we're going to argue. Our advocate, raised the question which wasn't answered in the ConCourt. If you have to declare 2 bottles of wine that are worth more than 350 rand, and that's mandated by the code. But as in the president's case, he had advanced an enormous sum to the election campaign of his own money. The Cyril Ramaphosa sort of funding vehicle repaid him 20 million of the money that he had advanced. If they hadn't raised enough money, if there hadn't been donations, he would have been 20 million rand out of pocket. Yeah. Now, that surely is a personal benefit. The court did not take cognizance of that, and we're going to have to, study it carefully and to understand why and how we can ask the High Court in turn to relook at that question.
Yeah, I mean, does that exist currently? And I mean, that is something that obviously needs to be very, very seriously looked at. And we know that, we saw what was happening with the promotion of access to information. That act that's just come in, and also the case of the Political Funding Party Act. I mean, these are very, very important acts, and we do know that they're here, they're with us now. Whether or not they're being fully implemented is an issue, because people want to know. They want to know who funds a party and in turn is benefiting because of the funding, and that's the reality.
Absolutely. Look, the Political Party Funding Act will greatly improve disclosure with regard to the funding of parties. But from our understanding of the legislation, it doesn't cover the funding of individuals in their contests within parties. And I think part of the solution may be not only the courts, but legislative reform. There needs to be a campaign for the whole gamut of political funding to become transparent and public.
Yeah. So those sealed bank statements, the CR17 bank statements, is there a chance now at all that they'll ever be unsealed?
Look, I think that's something of a red herring, because you may recall that certainly some news outlets got access to those bank statements, wrote stories about them. I think whatever scandals may or may not be in there have likely mostly been exposed. There was also a follow-up case in which we're involved, brought by the EFF for the court to formally unseal that. That has been argued. We haven't got judgment on that yet. But that should happen in due course. And we, again, in a sense, similar to the case involving the public protector, we took a principled position. We didn't say yes or no. We said, look, these are the principles governing keeping court records secret. And basically we argued that, it must be only in very exceptional circumstances that court records are kept secret. The default position is open. and I'm not sure that these records will qualify. We hope that the court errs towards the side of openness.
Yeah. I mean, you mentioned that, some of those statements have already been leaked. They've been spoken about in the media. And we are seeing those exact companies that have been spoken about in the media benefiting during this time. I mean, we are a country that is, trying to fight state capture. We're spending billions on a state capture commission that is having a look into what happened during the time of former President Jacob Zuma and his relationship with the Guptas and all other issues related to state capture. But it appears that not much is different in this legislative governance that we're seeing right now, that a lot of the same companies that perhaps did fund the president's campaign are benefiting. When we talk about state capture, this again is state capture at play, and how do we ever stop the cycle?
Look, I think one needs to be careful about being too loose about the relationships between donations and benefits. These kinds of donations are not illegal. They don't necessarily translate into influence. I think the point about making them transparent, having disclosure, is so that one can, check whether or not there is a relationship between, the benefit that a party receives or a politician receives and the actions that they take. I think, the efforts, for instance, to link donations to issues around the provision of vaccines and so on. Really, there's not a lot of evidence that I can see to support that. That's not to say we shouldn't ask those questions, and that those kinds of payments and relationships should not be disclosed. But I think one needs to look at the evidence, soberly and in all the circumstances.
Yeah, Sam. Finally, just as we wrap the interview, just on a closing note, in terms of the public protector, there were a lot of bruising things put forward in the judgment against her, and it really puts her in a much more precarious situation now when Parliament is already looking at her fitness to hold office. I mean, she's been found to have been wrong on a number of instances. She couldn't make the finding that Ramaphosa deliberately misled Parliament, then decided to insert the word deliberately without any evidence. She said the funds passed several hands, yet it was only in one account, and also didn't give an opportunity to the person investigating remedial action. I mean, where does this put the public protector?
Look, I think this is, yet another in a long series of criticisms of her handling of her portfolio. I think the judgment did not, call or for any kind of personal punitive costs, which she has had in other cases. I think they took a slightly more benign view of the lapses, but some of them in terms of especially the inserting of different words in the code and using those different, made-up words to make a finding against the president. That's very hard to explain as coming from someone just on the basis of a mistake or, with bona fides. That looks very much like that it's intentional. So look, but it's very hard to see this as she's so dug such a deep hole for herself. But this certainly adds to the evidence against her.
All right, Sam, we'll leave it there. We wait to hear from you once you've studied the judgment and, of course, see your next move in this. But thanks for talking to us again. Sam Soul is a journalist, managing partner of the Amabhungane Centre for Investigative Journalism, reflecting on the ConCourt judgment handed down yesterday on whether Ramaphosa misled Parliament in relation to the 500,000 rand paid by Bosasa donations made to the CR17 campaign.